Welcome everybody to this month's practice group session for the contract administration group. So with that, I'd like to give it over to Jim Rains and Douglas Freeman for today's presentation.
Welcome everyone. We're glad to have everyone back for another meeting. We will be continuing our discussion today on modifying the contract documents. This is the third session that we've discussed this topic. Just as a brief recap of what we discussed the last two meetings, we noted that changes are inevitable. We need to establish and follow the procedures for making modifications in our contract documents. In general, modifications must be within the scope of the contract. Typically, all parties must agree to the change. There are instances where the owner can direct a change that does not necessarily require that the contractor sign off and agree on a change order. And the architect can make minor changes that do not affect contract cost or time. And that's done typically within architect supplemental instructions. The owner and the architect initiate changes by issuing change proposal requests. The contractor responds to the change proposal request or initiates changes by submitting a change order request. Again, minor changes are done with an ASI. It's a change that does not affect the contract sum or contract time. Change directive directs the contractor to make changes before the owner and the contractor agree to the terms of the change, be it the contract sum or the contract time. And change orders are written instructions issued after the contract has been signed that authorizes additions, deletions, or revisions to the contract in consideration for an adjustment to the contract sum, the contract time, or both. And then we also discussed some protective measures or risk management approaches that can be used to help mitigate having change orders during the construction process. So this week we were going to review some case studies. We will be presenting some fact patterns or scenarios and offering up some potential results or situations as a result of those fact patterns, and we'll be asking everyone to vote on which one of those they think is the most likely result to happen. So with that, I will ask Jim if he has anything he wants to add before we start going through the case studies.
One item, just as a note for information, this comes out of the practice guide in Chapter 8, and we're looking at really 8.2, which are the contract modifications. So if you want to go back and reference the practice guide as to where this information is contained therein. So that's it for me, Doug. I'm ready.
Okay. Matthew, if we can go to the first case study. The first scenario is where we have an owner that approves a change and the architect recommends against the change. And the reason the architect is recommending against the change is because what the owner wants to do violates the building code. So what happens? Option 1 would be the architect goes along with the change. Option 2, the architect directs the contractor not to make the change. Option 3, the architect reports the change to the authority having jurisdiction. And option 4, the architect terminates his services with respect to the project. So if everyone can take the time to pick which one of those 4 options I think is most likely.
So it looks like most of the people have voted. So I'm going to close this poll and show the results for everybody here. So hopefully that'll pop up. There you go.
So we have a majority. As the architect reports the change to the authority having jurisdiction, and that's followed by the architect directs the contractor not to make the change. Next being the architect terminates his services, and last, the 4% saying that the architect goes along with the change. Jim, I'm going to let you chime in with any comments, and then I may follow up. And Matthew, if anyone has any comments from the chat box, we'd like to hear those as well.
Right. As the quick poll popped up, we're of course not clicking in to vote ourselves, but I agree with the majority of the group. I think that as we are charged with the protection of health, safety, and welfare of the general public, we are mandated to reply in a way that, you know, it assures to the best of our ability that codes have been met for the project. And I think the important part here is that there's a violation of code requirement. We know that as the case study is presented. We recognize that there's an obligation to report that so that our requirements as a license holder are met. And I don't know, though, that we necessarily direct the contractor not to make the change. We certainly inform the contractor of our knowledge that there is a code violation. Certainly the contractor has the ability to make independent decisions and should choose not to make the change based on that. I think, though, once we notify the authority having jurisdiction, at that point may be moot, because they, of course, would investigate the issue and make that notice to the owner that whatever the change is a code violation and it isn't acceptable.
Jim, I agree with you 100%. Most jurisdictions, and I know North Carolina is one of those, requires in our licensing laws, it's required legally for us to notify the AHJ if we become aware of a decision that the owner is making against our recommendation that violates the building code. So if you don't do that, you're running afoul of the licensing laws. Item 4 on here, terminating your service. That also is, at least in North Carolina, a requirement, but the way that it's written in there is if it's done a second time. So the first time you report it to the AHJ, if it happens again, then you can terminate your services and you won't be held liable for terminating those services. Now that may vary from jurisdiction to jurisdiction, but that is the laws in North Carolina. The first one, the architect goes along with the change. We only had a small percentage that picked that one. That one, I would say, is out of all of these case studies, if there's any right or wrong answers, that may be the only one that is 100% a wrong answer. One may be fearful of losing future work, or want to feel that the owner's always right and they need to go along with the owner because the owner's paying the bills. But again, the laws that govern the practice of architecture require you to report it to the authority having jurisdiction. You can't turn a blind eye to it. As Jim said, we are first charged with protecting the public, safe, healthy health and welfare, and turning a blind eye to it is absolutely not the right thing to do.
Matthew, are there any hands raised or any questions that anybody has posed about this one?
We just got a couple of comments here, so I'm going to go through the list here, kind of just addressing the one that Douglas just covered. We had a statement here saying that this poll is a difficult one to make a decision on, which I think we're going to find out a lot of these are going to have some difficult responses, because it kind of want to make you think about things. But the first one was actually selected in this person's case as the only logical one if the architect wants to keep a client. So I think much like Douglas had just mentioned about the issues between keeping business on the table and issues with licensing requirements. And indicated that in the third and fourth options are almost a guarantee that the client will go elsewhere. So again, kind of talking about what we just talked about. Two additional comments here. Under contract, the AE is not required to report violations of laws or regulations. AE is certainly not empowered by contract to direct the contractor's efforts, particularly against owner's wishes. Only alternative is for the AE to exit the project if the owner is adamant about violating the code. And additionally, similar comment, since the architect isn't under contract with the GC, the architect doesn't have the authority to direct the GC not to follow the owner's direction. And then lastly, we just had one pop in here that they agree, but if we choose item 3, the owner may invoke item 4 on their own.
Well, Doug, you know, Doug, I would just say, let me throw in there, Doug brings up a point that I think has been expounded on here, that is what the state licensure law requires of the license holder may be slightly more stringent than or restrictive than the contract with the owner. So in that case, you may be obligated to notify the authority having jurisdiction versus what your contract might require.
I actually had this situation arise on a project fairly recently where the owner wanted to add, I guess I can say this without getting in too much trouble, so the folks that know me and are from our firm will recognize this, but the owner wanted to add some additional paving to the site work that would have exceeded the impervious surface requirements. And again, in North Carolina, there are requirements that if you have so many square feet of land that you're building on, there's a limitation as to how much of it you can cover with impervious surface. And so this owner wanted to add some paving that would have exceeded that limit. What we did in that case was went to the owner and let them know that it was a violation of the city requirements and showed them the licensing laws that said if we are aware, we have to report it. And we told the owner, if you do this, if you proceed down this path, we have no choice but to go to the AHJ and report it. And once we explained it to them and educated them about what the situation was, that we were legally obligated to fulfill that duty to report it, they understood and did not add it, at least not under the scope of the work that we were working under. Whether they've done it since then, I don't know and don't care to know. But there were no hard feelings with it. The owner understood we had that legal obligation and did not fire us, but it was a bit of a delicate situation. So again, you could turn a blind eye to it, and if it's discovered that you did so, you would risk, as opposed to losing one client, you may not get repeat work from. You may risk losing your license and your livelihood to serve other clients. Shall we move to case study number 2?
We just had a couple additional things here to add. One, as a follow-up to an individual's comment saying it just seems like maybe the right thing to do is to inform the owner that you were obligated by your license to inform the AHJ. It may allow the owner to understand the reporting of the incidents. Therefore, you're not really burning bridges in the industry. And along that lines, there was comments here that are kind of popping up sporadically here. As a consultant, I could not see myself calling the law, in parentheses, on the owner unless I had first terminated my services with the owner. Again, probably talking about the idea of potentially not wanting to burn bridges in the industry. And then 2 comments here in a row from John indicating architects have 5 duties in corresponding order. Self, profession, public, employer, client. Can't do anything for the profession to violate self-duty. Can't do anything for the public to violate professional duty on down. Can't do anything for the employer to violate public duty on down. Can't do anything for a client to violate employer duty on down. Keeping the client is the least of our ethical concerns. And goes on to say professional and public could be interchanged. I can quit a client, I can quit an employer, I can change professions. My relationship as an individual to society, parentheses the public, is pretty inseparable.
Good comments.
Alrighty, moving on to case study 2 then.
Case study number 2, the contractor quotes excessive prices for a change on the project and refuses to negotiate them. So what happens? Option 1.
You know this is a fictitious case study.
Yeah, this never happens.
That could possibly happen. So we really reached out there to make this one up.
Option 1, you use a change directive which requires the contractor to perform the work on a time and materials basis. Option 2, the owner contracts with a separate contractor to do the work that was proposed in the change. Option 3, the owner just rejects the change proposal wholeheartedly. And option 4, if it's a federal or possibly a state-funded project, the contractor is subject to a False Claims Act violation. So now the poll is open, and again we'll give you time to make your selection and also to submit any comments through the chat. So Jim, how often have you seen this one? About every other week?
Well, I guess it does seem to happen frequently, and I think some of those are intentional, and some of those maybe are perpetrated by prices downstream that the contractor really doesn't catch, doesn't check, or passes along information without, they're going through their due diligence, and you could say as a mistake. We see that frequently, especially projects that have requirements for, a specified overhead markup or, those sort of general conditions that are tied to a specific number, and they're just not catching it in the paperwork.
Okay, we have our results back, and options 1 and 3 were pretty close, with 1 coming out just a little bit ahead, being that you use a construction change directive to have the contractor perform the work on a T&M basis. That's followed by the owner rejects the change order altogether. And then trailing behind are hiring a separate contractor to do the work, and the last one being a federal or a False Claims Act violation.
I think looking at the change directive opportunity, particularly in the projects that are state funded, and Doug and I are both in North Carolina, and we both do a lot of state work. This is one of the scenarios that the State Construction Office recognizes as a way to maintain the schedule for the project. So we can agree that we disagree. We can proceed with work so as not to negatively affect the completion date of a project. It's paramount that we get this dorm facility open, for example, for next year's fall new students. So it's a way to not harm the momentum of the project and keep things moving while everyone has longer to do their due diligence and verify, prices. And this scenario has afforded us the opportunity to, for example, as I described, find that a sub to the proposal, a material provider or something, counted something twice, or had double the hours, and sometimes by mistake, sometimes by design. But it provides for the project moving forward.
Yes, and I'm going to just chime in a little bit on each one of these. On the first one, using a construction change directive and proceeding on T&M. That has its own set of consequences where it could increase administrative requirements and monitoring to track the T&M and make sure that those numbers are in line. If you've got a contractor that is purposefully inflating his cost on change orders, just because it's being done T&M does not mean that he's not going to purposefully inflate the T&M charges as well. So you still have to do your due diligence there. Using a separate contractor to do the work, that can also be problematic. It could affect warranty issues. Just having a separate contractor on the job could be problematic. Delays, interference claims, and a whole host of issues that could happen there. Rejecting the change proposal outright could also have its set of issues, and if it's work that is required for occupancy or something that is necessary in order for the owner to use the building for its intended purpose, if it's just rejected outright and is not done, you got those issues. The last item I added in here, I'm not sure if a lot of people in North Carolina are aware. I think most folks are aware of the Federal False Claims Act, where if there is federal funds involved and someone submits a claim that's false, whether it's a change proposal request or a pay app that's asking for more money than they're due, or any number of things, if you're asking for payment or monies that you are not entitled to, you are violating that Federal False Claims Act and are subject to 3 times the damages as well as attorney's fees. North Carolina 2 years ago, 2010, enacted a statute that's very similar to that federal statute. So in North Carolina, with state funds, you'd also be subject to, again, trouble damages and attorney's fees and costs, court costs. So that is a tool we could add to our toolbox when we're doing projects that are federally funded or state funded, to kind of let the contractor know that we're looking at these things and they could be subject to a civil action for submitting a false claim. And in North Carolina and on the federal statute, that claim can be brought by any individual, a private citizen. So it's not like the state has to bring it or the attorney general. A private individual can bring that claim. So that would mean that the architect could sue, the owner could sue, a subcontractor could sue, anybody could sue the contractor for submitting that false claim. And the way it works is, if you sue as a private individual and you take the case on through and are successful, you get a percentage of the recovery, and then the state gets a percentage. If the state takes over the case and they take it through, you get a lower percentage of the recovery and the state gets a higher percentage of the recovery.
Doug, I'll just throw in, we here locally had a project that, and I know everybody has these stories, but it's just interesting that this particular opportunity opens up to the public. We had a contractor who was the #2 bidder on a project watch it carefully, legally, closely through open documents requirements, and found that on this project the contractor who was successful was doing this with something associated with site work, and began proceedings to do exactly as you just described, Doug, and be a party to the case, to the claim. For whatever reason, I don't know, he stopped that proceeding, but he was certainly within his right to do it, and had good, credible knowledge that it was going on.
Matthew, anything from our attendees?
Yeah, we have just a little bit here. So Michael wanted to just state that the time to material is not the only way to proceed with the CCD, and you may continue to negotiate or use unit prices. Was a little bit of a comment here from Michael's side. And then we have a question here, and I just want to precursor at the beginning of it. There is an indication from the individual that this may be an actual case study he is dealing with that may or may not be going into a lawsuit now. So feel free not to answer if you feel like you don't want to be necessarily used as legal advice. But from a case point here, a revised issue for poll number 2, the contractor price is considered reasonable and the architects agree. But the owner says it's still too high and instructs the architect to issue change directive. The architect did this in this case. What is yours or the audience opinion? To clarify, on the previous, the contractor performed the first change directive, but they refused when the second one came out. The second change directive can be performed without affecting the scope of the work. Can it be added on a later day?
So my first comment would be that the contractor, if the contract is based on or very similar to the AIA contract document language, that contractor cannot refuse to perform work that's issued by a construction change directive without being in violation or without being in breach of their original contract. When they sign that contract, they're agreeing to proceed with construction change directive work immediately, and not doing so would be a breach of contract. In terms of the owner rejecting that proposal, even though the architect recommends its approval, the owner obviously has the right to do that. If the parties can't sit down and come to some type of an agreement or negotiate a settlement, I don't know that there is an alternative other than whatever dispute resolution procedures there are within the contract.
Okay, well, that is the only question at this point. Kevin O'Bjorn did comment in, Douglas, confirming that you are correct in your statement that you'd indicated with the AIA document. So seeing no other questions, I guess we can move on to case study number 3 here then.
Architect and contractor approve a change order. The owner verbally approves it but doesn't sign the change order. The contractor submits a request for payment. What happens? 1, the owner refuses to pay because no valid change order was signed. 2, the owner goes ahead and pays the additional cost. 3, the owner sues the architect for negligent performance for signing the contractor's pay app that was submitted. Or 4, the architect pays half and the contractor absorbs the other half. So you can go ahead and make your options, and I think by now everyone can see that these options that we are listing are not necessarily exhaustive. There could be other options. This is to generate discussion and get folks thinking. Not all the answers are going to be right, not all the answers are going to be wrong. And again, this is just to get some discussion going and get everyone thinking about these different issues and how we might best handle them.
You know, one of the things, Doug, I'll just add while everyone's making their selection, that it would be interesting to know the number of times that we get ourselves into our own trouble by not following the documents that we prepare. You know, we, for example, will say to the contractor, in this scenario, you cannot get paid for change order work unless it has been authorized, and it cannot show up on your pay application until it is official. But yet they do show up, and we do process them because we're we overlook it. We're trying to move too quickly. We're trying to handle too many things at one time. Whatever the reasoning behind it is, we paint ourselves into these corners. It's almost as if we don't need help getting in trouble. We can do it ourselves pretty well.
Yeah, I agree. So we have our results, and the majority of people are saying that the owner is going to pay the additional costs, followed by a smaller percentage that is saying the owner refuses to pay because no valid change order was signed. And no one picked options 3 or 4, which I find interesting. Again, on this one, I don't know that there is a right answer or an answer that is most likely to happen. If there was one, I think I would go along with number 2. I could certainly see if there was no documentation, no way to prove that the owner verbally agreed to something, and as Jim was saying, we get ourselves in trouble and we get signed off on a pay app that includes this change order item, that the owner may want to file a claim against the architect for negligence in signing a pay app that includes the change order that was not, or some change work that was not issued in a change order. I've certainly been aware of cases where when there's a dispute over an issue and the owner says, no, I'm not paying, that the architect and the contractor work some kind of deal out where they each are responsible for part of the cost, whether it's 50-50, 70-30, or whatever. So again, on this one, I don't know that there is a answer that is necessarily wrong. I think any one of these could happen.
Could occur, right. I think, and I'll add to that, it depending on what the architect did and depending on what the contractor did after this verbal conversation, as Doug said, this is not an exhaustive list, and you can take each one of these and paint a scenario around it. Well, if this had happened, it would go this way. If this happened, it would go another. If there was documentation to prove or confirm that the owner had verbally approved the change, if the contractor and the architect were there together, those things would start to move the answer in one direction or another. I have seen, I could add a 5th one here where the contractor just didn't get paid for the work. I had a project that was with the state construction office that closed out. The contractor signed all the final documents and turned them in, and some weeks afterwards realized that there was a change that the architect and owner and contractor had agreed to, but it wasn't formally documented and it wasn't forwarded for signature. Everybody just sort of forgot it, not maliciously but by accident, and they didn't get paid for it because they had closed the project officially and there was no money left. So there are definitely different scenarios depending on the parties involved.
Matthew, looks like we may have some comments.
We sure do. So we're going to start here at the top. From Kevin, had a couple comments here about although we selected the first choice in the poll, the third option was also valid or could be valid. But with that being said, in this scenario, the owner appears to be disingenuous, which apparently never happens. But indicates that if owner pays additional costs without a change order and then terminates contract later, the surety would be interested in knowing why the owner paid the contractor more than the contractor was due in the contract. So that's kind of an interesting twist on that as well to look at. Additionally, Michael Seitz indicated that he would recommend the architect sign the change order last after the contractor and owner have signed. That way then you can always kind of at least cover your own point of view on things. And additional comments here indicating owner is required to pay the amount certified by the architect. Owner may then file for dispute resolution. But finally, the owner's approval, in air quotes, really constitutes authorization, and contractor has an affirmative responsibility to ensure owner signs, which looks like, let's see here, another one just popped in here from John as well, saying architect's approval is with appropriateness of costs associated with technical scope, whereas the negligence if the contractor proceeds to execute without the owner's approval. And then I have a couple of comments also in the chat feature here indicating from Tom Montero here, if a CO isn't signed and the GC is not authorized to proceed with the work, should the owner refuse the CO, no one loses. And then additionally, there's no indication that the CO was submitted on a pay app, therefore the work was not supposed to have been performed. And then lastly from Jim, typically the specs state that the contractor will perform no change order work without an approved or fully executed change order. The common understanding is the contractor will perform the change order work before the change order is executed. Again, this is at the risk to the contractor.
I'm going to reserve comments, as I think some of the later case studies might touch on some of these issues. So let's keep going.
All right, so we are moving on to case study number 4.
The owner approves a product change suggested by the contractor without the architect's knowledge. The product fails, causing damage to the building. What happens? Contractor is responsible for repairs and replacing with the specified product. The owner pays for the repairs and replacing with the specified product. The owner sues the architect for negligent performance of CA services. The architect pays half and the contractor absorbs the other half. So 3 and 4 are the same options from the previous case study. All right, as we're taking the votes here, given time for the votes, I will go back and make a couple of comments on some of the discussions on the previous case study. The negligent performance for signing on case study 3 was assuming, and it may not have been clear, that the contractor submitted a pay app, the architect signed off on the pay app, and the pay app included the change work. So the cause of action that the owner have against the architect would be for the architect signing a pay app that included a change order that was not authorized. As we were saying, there's depending on the particular facts and circumstances of the project, that one could go a number of different ways. Those options were not meant to be exhausted, but again, just to help generate some discussion. Mainly to point out the importance of following the procedures that you establish in the contract documents. There are cases where you can have a change that's valid that the contractor would be entitled to payment for, even though a actual written change order was not in place. I see we have our poll results, so let me finish up that thought real quick. Course of dealings, knowledge, implied consent. There's a number of factors that could go into whether or not that change is going to be considered by a court to be a valid change without actually having it have been written out and signed as a change order. So our poll results, most of the people say that the owner is going to pay, and that is followed by just a slightly smaller percentage of the people that are saying that the contractor is going to pay. And again, no one is picking items 3 and 4. Item 3, again, I think could come into play. And again, it would be a disingenuous owner where the owner says, well, Mr. Architect, you wrote the documents, you knew what was specified, you saw that the contractor put in something that wasn't part of the documents, you didn't address it, you're negligent. If the architect doesn't know that the owner has approved this product, he may not be aware of that, and I think that the fact that he doesn't know, he's not going to necessarily have a defense to say, well, no, Mr. Owner, you made this change, not me. I didn't approve it. So there could be a situation where item 3 does come into play. Item 4 may be less likely to come into play, but again, if item 3 happens and the owner saying, Mr. Architect, you were negligent, especially if it's a major client, a repeat client, the architect can make a business decision to go to the contractor and work something out. So again, I think all 4 of these options are possibilities. My personal opinion is probably that item 2 would be the one that would be the most likely, or at least the most desirable result, is that the owner be responsible for making that decision and responsible for paying for that repairs.
And I think that I agree with that, Doug. And I think the again, making some assumptions such as we do have a good owner here, and that they weren't trying to swindle anybody. They made a mistake. You know, that would seem to be the proper scenario. Perhaps they felt like there would be a better quality product for less money. They had a hope of saving some of the project funds there. You know, there are so many nuances to what could be going on when you see something like this. Typically, when pre-construction conferences are held, there's a long list of information that's reviewed, and one of the critical things is, here are the people who are in responsible charge, who are allowed to make changes. This is the scenario under which those changes can be made. And if that process is well documented, that would drive the answer to a question like this. We could go back and say, here's where we told you not to do that, and since you did, you know, Mr. Contractor, we're looking to you to fix it because you shouldn't have. So I see 1 and 2 as the most likely scenarios, unless you do have some underhanded process going on, which is a whole different webinar. Matthew, any questions or hands raised?
We have a few more here, starting at the top here for case study 4 is working on here. If the AE did not approve the substitution request, then there was no substitution, so the contractor was contractually obligated to provide the material or equipment specified on the contract documents. Of course, owner needs to better understand their limits of authority for their work. Additional comments here coming from Michael include, a change in products is a change to the contract documents, thus it should be documented by a change order executed by all 3 parties. Product should be reported by the architect to the owner as non-conforming work. And then we have 2 additional comments down here saying Division 01 specs should cover this situation, that the contractor has a responsibility to install proper products. And lastly, comment up top, looks like I have a couple on the bottom I have to look at yet. If the contractor recommended the change, he would be responsible, coming from Randy here. And then we have a conflicting statement down here saying, disagree with the architect being responsible for catching the use of the product unless the architect has more CCA than periodic visits. The problems weren't caught until after the product was installed.
Okay.
And looks like I have one more hand raised, so if you guys want to have any comments on that, we'll get that answered.
Well, again, the purpose of this, and I think we're getting some good comments, some good feedback here. The purpose of this, again, is to just point out these different scenarios. As everyone that we've talked about so far, I've seen happen on a job at one time or another. And it, again, goes back to the risk management discussion we had last time, what do you need to do to help limit your exposure for these type of conditions, and all the stuff that we're talking about, making sure you follow the procedures that you put in the documents. A substitution request submitted by a contractor is not a change to the contract documents. It needs to be memorialized in a change order. I mean, all those things that we've been talking about. If you don't follow those procedures, you could find yourself in trouble.
Okay, we got some clarification on, I think probably the last comment for this one. A contractor will argue that when a product is approved by owner or AE, then the contractor is immune from any recourse.
I think that goes back to the comment about the Division 1 portion of the specifications, and if you have prepared yourself appropriately and have the required documents included in the specifications and have that process established for a change or substitution, as it may be called, which is a segue into what we're going to do next call, then you may be protected from the issues that we're talking about here. But that's the place to take care of being sure that it's established how to change.
Okay, case study number 5. The building inspector tells the contractor he is not going to issue a certificate of occupancy until certain additional work that was not in the contract documents is performed. The contractor performs the work and requests payment. What happens? And it's in that order. The contractor does the work, there was not a change order issued, and then the contractor is asking for a payment or submits a change order request. Option 1, the owner is not required to pay because no change order was signed. Option 2, the contractor is entitled to payment even though no change order was signed because he did the work and the inspector would not issue the CO until the work was done. Item 3, the owner sues the architect and the architect pays because his plans did not comply with the building code. And item 4, if the work requested by the inspector is not required by code, then the inspector pays the contractor. Jim, as they're voting, do you want to start off with any comments on this one?
I hope I live long enough to see an inspector pay for something. not to mess with the voting, but boy, wouldn't that be something?
We were having a discussion in my office earlier today about submitting plans and having the reviewer tell you one thing, and then get out in the field and the work's pretty much installed or has been installed, and then the field inspector tells you, no, you got to do something that's contrary to what the plan reviewer told you to do.
Right.
So again, where is the inspection responsibility for giving you bad information?
And all the ones that I've experienced, it doesn't matter. All right.
Okay, 50%, majority of the people say that the owner is not required to pay since no change order was signed. And then about a third are saying the contractor is entitled to payment since he did the work and it was required by the inspector. A smaller percentage say the architect pays because his plans were non-code compliant, and then a smaller percentage says the inspector pays. I'm like Jim. I don't know that I've ever seen an inspector or an inspections department pay for anything. I could see the other 3 happening depending on, again, the facts and circumstances surrounding the whole project. If you have established procedures and you follow them to the letter, and the contractor runs off and does some change order work because the inspector or anyone else told him to do it, even it being the inspector, the authority having jurisdiction, he does it without getting the proper approvals, he is not entitled to payment for it. He has not complied with the terms of the contract. And I actually have had that happen on a project before. A contractor may be able to validly make a claim under item 2 that, well, the work had to be done, the owner couldn't use the building, I'm, as a licensed contractor, obligated to comply with code, I had to do it, the owner, it wasn't in my scope, the owner has to pay for it. You can make a unjust enrichment claim, the work was done, and again it had to be done, or the owner wouldn't have been able to occupy the building, the owner got the benefit of the work, and so the owner isn't obligated to pay for it. And if that is the result, I can certainly see the owner turn around and say, no, Mr. Architect, your plans don't comply to code, you pay for it. So again, I could see all 3 of the first items happening. I don't know that the 4th item would ever happen.
Yeah, I would be really interested in any of the attendees having knowledge that an inspections department was held responsible. I do know that there have been scenarios out there, I just can't recall now, not on any projects I've worked on, but I was going to say it's sort of, my experience is sort of a combination of the first 3. While the owner isn't obligated to pay, they typically do end up paying because the contractor had to do the work in order to meet code, and that's the assumption here, that this is work that was required to meet code. The building inspector required something that had been missing, and that because of that, the architect may be invited to the table to participate in some portion of that cost because it would have been less expensive to get it done if it had been in the original bid documents. And that sort of scenario, at least in my experience, happens frequently, especially when you're at the end of the job, and more typically if everyone isn't as happy as they could be. If it's going smoothly and everyone's happy, then you know, usually the owner, even though they aren't required, will pay for those kind of costs because they had to be done.
What we got from?
Sorry, go ahead, Doug.
What have we got from the attendees, Matthew?
Alrighty. So we have a comment here from Michael. When the contractor recommends a product, they may be open to implied warranty issues. That was actually a comment from the previous case study, but wanted to just point that out as a statement from Michael. But indicated that with this case study, seems like a really good time to use a CCD, which is kind of his joking comment there for us. And then Alan is kind of being tricky here. He didn't answer the question because even though an inspector may require something to be done by the contractor, it is possible that is not a code requirement, and the architect would not be responsible for paying for something that provides added value. And then we have a few more comments down here. With regard to your comment about the AHG requiring work, the GC typically tells the AE about the requirement, and the AE, in their opinion, must contact the AHG office to confirm requirement. And we have some comments here. The contractor is required to report the requested work per the inspector to the AE to allow for due process. The AE may have additional information that would provide another reason for code compliance. And then lastly, in regards to your question for anybody's case studies on the inspection office, the item did happen on a project in Tampa where the inspector brought up an item after it was already covered up, and the AHG negotiated with the GC to correct the issue.
Okay. A couple of comments that were made were saying that the contractor is supposed to inform the architect of the AHJ's requirement or request for the additional work to be done. I would agree that they should, but I know I've been on projects where they haven't, and they've just done the work and then you're in this situation again as to what happens when they do it and don't say anything until after it's done. And actually, I've been in a situation where an AHJ said, this needs to be done. The contractor did it, came to our firm and said, here's my change proposal for this worker. AHJ said I had to do it. And no, you didn't have to do that. Code doesn't require it. Here's how we're meeting the code. And the AHJ looked at it and said, yeah, you're right. And so the contractor went ahead and did the work without telling anybody when the code didn't require it. And the AHJ, after reviewing our methods, agreed that it wasn't required. And in that case, again, we did not approve the change proposal.
We have one more comment here coming in from Kevin. Contractor not responsible for implied warranty under the UCC. Rather, the manufacturer seller is responsible for the contractor. Is responsible to the contractor for the implied warranty unless the purchase order or contract documents contain explanatory language. So that kind of goes back to the comment that was a recap over from case study 4 into our most recent case study. Douglas and Jim, I'm not sure where you're at right now. We do have 5 more case studies to go. However, we are 2 minutes after the hour, so I will leave it up to you to decide if you want to postpone the additional 5 or what would you like to do next?
Well, I think we had some good discussion today. I would like to respect everybody's time. We had committed to an hour, and I see already we've had a few people drop off. So my suggestion would be that we hold these and maybe discuss them at a later date.
Matthew, is it possible to post these as a part of the information on the website such that people could reply to them, and perhaps we could start off the next session not going through each one but just taking a quick look at the responses to the polls?
I'm not sure if we have the ability to do polls within our website. We might. Let me check and find out. If not, perhaps I will send out the poll for all of these questions to everybody that is a registered subscriber of the practice group, because there's about 600 people on that email list, and get that information back from everyone to compile that info prior to the next call. So I can do one of those 2 ways to make sure that we get this going before the next call. No problem.
Well, maybe you, Doug, and I could have a conversation offline to see what's the best way to do that, and then bring that back at a later date. We'll just do that offline.
That sounds like a plan.
Okay.
Okay. So our next session, and Matthew, if I'm stepping on your toes, you can tell me to be quiet and you can do this. But our next session is scheduled for next month, August 21st, again at 12 p.m. That's the 3rd Tuesday of the month. And the topic will be substitutions, and depending on the discussion that Matthew and Jim and I have, we may start that out with wrapping up with some discussions on these case studies we didn't get to. So again, thank you for participating. Questions, comments you want to send, please feel free to send them, especially now that we've got the website up. Thank you, Matthew, for getting that up and running. If you have a topic that you would like for us to discuss, please feel free to send that in as well.
There you go.
All right. Well, thanks, sir.
Look forward to August.
All right. Well, thank you very much to both Douglas and Jim, as well as everyone else's comments and questions as we went through today's presentation, and look forward to either on the website, email, or some other way that we'll be able to get your information on additional poll questions on those remaining 5 case studies prior to next month's meeting.